The secret world in a few minutes. Journalists can breach the Official Secrets Act if they disclose information without permission, knowing or having reasonable cause to believe it is protected, and they know the information in the protected categories is what is described as damaging. Categories include security and intelligence, defense, international relations, crime, information on government phone tapping, interception of letters or other communications, information entrusted in confidence to other states or international organizations. The UK state persecutes and terrorizes potential whistleblowers and journalist sources. In other words, Crown employees, officers working in intelligence. If they want to put anything into the public domain, they have to go before a secretive investigatory powers tribunal, which has been criticized for giving decisions without reasons, though it does have a website publishing some of its rulings and has held some of its proceedings in public. Journalists who annoy or embarrass the UK state can still have the indignity of being arrested and their homes, offices, papers, files, and computers searched. So a rather unpleasant message is delivered without any further legal action following. Though recent cases where the arrest and searching was unlawful, one in Northern Ireland and the other in Kent in England, resulted in damages and compensation to the journalists. Sensitive stuff that might relate to terrorism, intelligence, torture, and rendition is kept from the public by the use of special advocates in SIAC hearings and other areas of litigation. In total secrecy, suspected terrorists received lawyers who can't communicate with them, but can see, hear, and challenge the secret information used against them. In 2013, the UK government expanded this process into the rest of the legal system in what they called closed material procedure. The identity of secret witnesses, unknown to the defense, is a standard practice in many criminal trials. Some witnesses appear as pseudonyms, others as letters or numbers. Terrorism legislation provides no public interest defense for journalists and media workers who do anything that knowingly assists the preparation of acts of terrorism. There is a positive obligation in criminal law for journalists who have any knowledge about terrorism to report the information to the police. In 2014, The Guardian challenged an Old Bailey judge's decision to hold an entire terrorism trial in secret with the identity of the two defendants anonymized. The appeal court ruled that the accused should be named and elements of the trial had to be heard in open court, including swearing in of the jury, reading the charges to the jury, part of the judge's opening remarks to the jury, part of the prosecution opening the verdicts, and sentencing in the event of guilty verdicts. Accredited journalists were also permitted to attend much of the in-camera proceedings, provided they agreed to be bound by confidentiality and left their notes with the court at the end of the day. This means that should the reason for the secrecy ever be lifted, the media will be able to report what happened behind closed doors. But this has not happened in this case, and a challenge by newspaper groups was unsuccessful.